Indiana judge upholds abortion ban, rejects expansion of exceptions. An Indiana county judge has ruled against abortion providers and advocacy groups seeking to broaden access to abortion under the state's near-total ban, enacted in 2022 after the U.S. Supreme Court overturned Roe v. Wade. Judge Kelsey Blake Hanlon, who presided over a 3-day trial in May, issued an order on September 11th that denies a request for a permanent injunction sought by Planned Parenthood and the American Civil Liberties Union of Indiana, which mounted a legal challenge against Senate Bill 1. SB 1, which was signed into law by Governor Eric Holcomb in 2022, prohibits abortions except in cases of rape, incest, lethal fetal anomalies, or when a woman's life or health is at risk. Indiana was the first state to enact a near-total abortion ban after the Supreme Court's Dobbs v. Jackson Women's Health Organization decision returned to individual states the authority to determine their own abortion policies. In their lawsuit against SB 1, the plaintiffs wanted to expand the law's medical exemptions and block the requirement that abortions be performed only in hospitals. They argued that the exemptions for protecting women's health are so narrow that doctors often hesitate to terminate pregnancies, sometimes in medically justified cases. They also argued that the hospital-only requirement increases the cost of care and limits access. In her 50-page ruling, Hanlon upheld both of the challenged provisions of SB 1, concluding that they do not violate constitutional protections and that the plaintiffs didn't provide examples to support their arguments. Plaintiffs have not shown an instance where an abortion is necessary to treat a serious health risk but would also fall outside of the health and life exception, Hanlon wrote, adding that medical professionals have shown an ability to apply the law's health and life exceptions, ensuring that necessary care is provided. Additionally, plaintiffs have not demonstrated that the hospital requirement is materially burdensome to constitutionally protected abortion access, nor that it fails rational basis review as to statutorily authorized abortions, she wrote. Hanlon said that strong evidence was presented on the impact of SB 1 on medical professionals, but emphasized that the court cannot override the policy decisions made by the Indiana General Assembly. The judge noted that the statutory definition of serious health risk in SB 1 puts Indiana doctors in the incredibly unenviable position of providing exigent obstetrical care in a politically charged environment and under a new statutory regime that includes potential criminal liability and license revocation. However, she wrote, SB 1 allows abortion when physicians believe, based on reasonable medical judgment, that a woman would face a serious risk within the meaning of the law. In response to the ruling, Indiana Attorney General Todd Rokita hailed the decision as a victory for the state's pro-life movement. Another huge win for life. Today, the Monroe County Circuit Court denied Planned Parenthood's motion for a permanent injunction against our pro-life law, Rokita said in a statement on X. Indiana's abortion providers and advocacy groups issued a joint statement saying they remain steadfast in their opposition to the law, which they said leaves Indiana residents with dangerously limited options when seeking to terminate a pregnancy. Hoosiers with serious health complications have been forced to endure unjustifiable suffering due to miscarriages, ectopic pregnancies, and other pregnancy-related issues, or leave the state to access appropriate care, reads the statement from Planned Parenthood, ACLU of Indiana, All Options, and the Lawyering Project. The plaintiffs are expected to appeal the ruling. In the meantime, Indiana's abortion rate has dropped dramatically. According to the Indiana State Department of Health, 27 abortions were reported in the second quarter of 2024, a 98.6% decrease compared to the 1,938 abortions that were performed in the same period in 2023, when Indiana's abortion law was still blocked by the courts.